Good morning, everybody, and welcome to our 2022 Virtual HOA Condo Academy for our class number 7 for the month of July. Thanks so much for joining us here today to discuss hot topics for HOAs and condos in 2022. We're really happy to be here in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. And I'm sorry if you just heard a little bit of background noise. We're having just a little technical difficulty, but I think we're working it out. Well, welcome. My name is Beth Mulcahy, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed representing HOAs and condominiums for over 25 years, and my firm currently represents over 1,000 planned communities and condominiums throughout the state of Arizona. I currently serve on my HOA board, and I have for many years. Before we dive into the meat of this seminar, I'd like to start off by getting a feel for who's in my audience today, so I can tailor the information to best serve all of you. So at this time, we're going to be launching 2 polls for those of you who are joining us on Zoom. The first question is, which city do you reside in? And there's a number of options on the Zoom poll. And then the second question is, let us know your current role in your association. Are you a board member, manager, interested homeowner, or other? And in a few minutes, we're going to be reading the results of this. So we're going to give a little time for it to come up. Okay, so first, what is on today's agenda? While we wait for those poll results to come in, let's talk about what we're going to be discussing today during today's seminar. Hot Topics is one of my favorite classes to teach because we're able to cover a lot of territory on a lot of different topics quickly. And these topics typically are either new issues that may come up, in our practice area, or new problems that associations may have, or maybe like cutting edge areas that are, becoming questions for the future, or maybe we see it coming in the horizon. It allows us also to take a deep dive and take a closer look at most of the important and pressing topics that are pertaining to community associations. So in preparing to teach this class here today, what we decided to do was we took a look at the type of questions that come into our firm, number one. And then also we started to monitor various news sources in Arizona and around the country. We also have been attending a number of cutting edge seminars pertaining to associations. And so we really try to give you a 360 view of what are the hot topics that pertain to associations right now. So for our results for which cities are present here today, we have the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. I think that this is the first time that we have ever had 100% participation from all of these different cities. So great job to all the neighborhood services departments that are partnering with us to create these classes, because we have truly a full representation from all of these cities. I'd like to give a special shout out to Scottsdale, Phoenix, and Mesa because they had the highest percentage of viewers here today. Okay, let's switch gears and look at what's the percentage of people that are here, what positions do they hold, and what's their interest in the community. So we have 63% of the viewers that are here with us today are board members, 10% are managers, and we have 19% interested homeowners and 8% others. So we have a really strong representation today of board members, managers, and homeowners. So that really kind of gives us a good 360 perspective from all different angles of different people in our industry. So right now we have 160 people joining us here on Zoom this morning. I can't believe that. I think this is an all-time high. The only other time that we had maybe a higher percentage was maybe like in March 2020, when we were in the, knee deep in the pandemic. So thanks so much for being here today. I promise this is going to be a very worthwhile class for you. We also have a number of people joining us on Facebook Live this morning. So thank you also for joining us here as we navigate this presentation. Okay, the first hot topic we're going to be talking about is the Arizona legislature and what happened this year in the Arizona legislature and what laws are going to be going into effect that are going to impact planned communities and condominiums. So as you may have heard, our 2022 legislative session ended on June 24th, and it was one of the longest sessions in Arizona's history, lasting 167 days. Arizona is unique in that we don't have a full-time legislature. Typically, legislature is only in session somewhere between 3 and 6 months each year. And so having such a long session this year, almost a full 6 months, was record-breaking for sure. It was also one of the most active legislative sessions for HOAs and condominiums in the history of, since I've been monitoring legislation for a quarter of a century. And so there were 25 bills introduced this year pertaining to HOAs or condominiums. And that's, a record high, especially after the past 2 years where we've had very little legislation regarding associations. Ultimately, our Governor Ducey, signed into law 5 bills, and we're going to take this as our first hot topic this morning. What are the new laws that are going to be impacting and applying to associations? So let's take a look at these new laws. The first one is House Bill 2131. And this is talking about artificial grass and prohibiting associations from banning the use of artificial grass in associations. This law only applies to planned communities, so that's a very important distinction. And basically, the gist of the law is that planned communities cannot prohibit the installation or use of artificial turf or artificial grass on a member's property. There are some things an association can do, however, to make sure that the artificial grass is, maintained, etc. So a planned community can, however, adopt reasonable rules regarding the installation and appearance of the artificial grass, as well as its location on the property, and the percentage of property that may be covered by using artificial turf. Additionally, an association can require the removal or replacement of artificial grass or turf if it causes a health or safety concern and it is not maintained in accordance with the reasonable rules established by the planned community. If a planned community's documents allow natural grass on a member's property after the time of developer control, the association cannot prohibit installing or using artificial turf on any member's property. But again, as I stated, a planned community can adopt rules regarding the installation and appearance of the artificial turf, just as long as those rules don't effectively prohibit or prevent installing artificial turf. And the location and property of on the property and the percentage of the property that may be covered with artificial turf can also be addressed in the association's reasonable rules. And so those are kind of some important checks and balances in place to make sure that whatever artificial turf is installed, that it's maintained and that their association has some ability to regulate it. A planned community can also require the removal of the member's artificial turf if the artificial turf causes a health or safety issue, as we stated above. And if it's not being maintained, the artificial turf, we can also have that. The association can also require that the member remove it. A planned community can prohibit artificial turf in a planned community in these situations. So there are a couple of exceptions, and these are the exceptions. If it's installed in an area that the association maintains or irrigates. So sometimes in an association in a planned community, the common areas or the front yard areas that are actually on an owner's lot are maintained by the association, or maybe the association controls the irrigation on these areas. In those cases, the association can prohibit the installation of artificial turf. If a planned community prohibits the installation of natural grass on a member's property, the association can also prohibit new installation of artificial turf on a member's property. Except that in that instance, an association may not prohibit a member from converting natural grass to artificial turf on a member's property. So obviously that's kind of an obvious exception. If a court finds that a planned community or an HOA violates this law, a court has the ability or shall award attorney's fees and costs against the association. So there are some penalties if the association doesn't comply with this. One important thing to note is that if your association has unique vegetation and geologic characteristics that require preservation, maybe like NAOS areas, and in which the viability of those characteristics is protected, supported, or enhanced, the result of the continuing, it's needed to keep that NAOS area, for example, the association could prohibit having installation of artificial turf in those areas. Okay, so that's the 411 on artificial turf. I have had a couple of associations previously to this law being introduced this year. So we've had issues with artificial turf being installed in the association where maybe some members were unhappy with somebody placing artificial turf in their neighbor's front yard or whatever. And in my experience, it has worked out just fine. At first people were opposed to it, but then when they saw how high quality it looked and how it looked nice 12 months of the year, and after its useful life is over, it's replaced with something else. And it saves water usage. It is something that is definitely things that associations are initially reluctant to allow, but after they start to see more owners doing it, they see the benefits of it. So if you're on this call today and you're concerned about a number of members installing artificial turf on their property, have an open mind, because in my experience, it has been a win-win for many associations. Okay, the next law that we're going to talk about is House Bill 2158. And this talks about political activities, community activity within a condominium or a planned community. So this law applies to both condominiums and planned communities. And it states that an association cannot prohibit a unit owner or a member from peacefully assembling and using private or common areas of the community. The association may not restrict owners from posting notices of meetings on physical or electronic bulletin boards, such as like your website of the association, for posting notices of board of directors, officials meetings. So basically what this law is saying is that owners can peacefully assemble to discuss issues. And if the owners want to put a notice on the association's bulletin board of these meetings where they're going to be peacefully assembling, the association has to allow them to put the notice of the meeting on, any place that the association would put their regular notices of meetings for board meetings or maybe even an annual meeting. Where are we going to see this come into play? You never know. But what I can tell you is I think probably a likely time that we'll see this is when we have owners that are upset about something. So maybe they want to remove the board from office and maybe they want to have a meeting to discuss it. Or maybe they aren't happy about a capital improvements project or a 5-year plan for the association. Or maybe they're unhappy about an increase in the assessment rate or a special assessment, something of that nature. So what I anticipate is that we will start to see more peaceful assembly requests, and maybe it'll just be informal and they're just going to be meeting on the common areas. Important for the association to note that we can't prohibit that. Now, I think there is definitely a difference between, a peaceful assembly of homeowner association or condominium members on the common areas versus like a march or something regarding, maybe a different issue where there's a lot of people coming in who don't live in your association. And, I think that's definitely a different situation in my opinion, and is not covered by this law. Okay, this bill also goes on to expand the definition of a political sign. And so as you probably know, and we're going to be talking about this as another hot topic a little bit later here today, but political signs are in full swing right now throughout Arizona with the primaries taking place and with the national elections coming up in November. And so basically this law also, in addition to addressing peaceful assembly, also talks about, political signs. And it says that the political signs, of course, that are allowed under Arizona law to be displayed on an owner's property, those typically were reserved to federal, state, local elections or propositions that might be introduced. Well, this new law expands the ability of an owner in an HOA or a condominium to have a political sign on their property for any activity to elect or remove a condominium or a planned community director, or in support or in opposition to a measure that requires a vote of the association membership. So basically, this bill also expands political signs in a way that not only does it apply to state, federal, and local elections and propositions, but now it also is traversing over into talking about association issues. So election of directors, removal of directors, important association issues. Do I think that we're going to see some homeowners putting up political signs for association issues or election of association directors? I think it's going to be pretty few and far between. But if you see this happen in your community after the effective date of these laws, you just need to note that owners are allowed to do this. And we'll talk about the timelines for how long they can keep them up shortly. Okay, another thing that this bill is going to prevent is it will prevent the association from prohibiting or unreasonably restricting a unit owner's ability to peacefully assemble, as we talked a little bit before, if it's done in compliance with reasonable restrictions for the use of the property adopted by the board. So when owners, if you're seeing a rise in owners wanting to peacefully assemble in your neighborhood, the board has the right to pass rules regarding those peaceful assemblies. So, we have some sample rules if anybody's interested in seeing them. We're going to be releasing those either later this week or next week through our Mulcahy memo that we send out weekly. So stay tuned for those, and we'll give you some examples of some things that you might want to consider. Let's see. Just anything else in this law? I think a couple other parts of the peaceful assembly, some areas that might be covered. I think we pretty much covered everything on that. So House Bill 2010 is the third bill that we're going to be talking about here this morning, and this talks about first responder flags. This bill, of course, is a bill in direct response to the pandemic that we are, hopefully winding down from. And basically, this new law applies to planned communities and to condominiums, and it adds a first responder flag and a blue or gold star flag to the list of flags that an association may not restrict the outdoor display of. And so a first responder flag is defined under the law as a flag that recognizes and honors the services of any of the following. So law enforcement, and that is limited to the colors of blue, black, and white. And the words law enforcement, police, officers, first responders, honor our, support our, and department, and the symbol of a generic police shield in a crest or star shape. A first responder flag can also be defined as fire department flags, and that would be limited to the colors of red, gold, black, and white. The words fire, firefighters, FD, FD, first responder, department, honor our, and support our, and the symbol of a generic Maltese cross. The third type of first responder flags that would be covered by this new law would be paramedics or emergency medical technicians, and that's going to be limited to the colors of blue, black, white, and the words first responder, paramedic, emergency medical, service, technician, honor our, support our, and the symbol of a generic star of life. And so basically the first responder flag is just something that if an owner wants to display on their property, they are allowed to display that now under this new law. Okay, the last two laws we're going to be discussing, were just passed a couple of weeks ago, kind of the last two that came in, under the wire, so to speak, after the budget was passed for our legislature. The first law that we're going to be discussing is going to be dealing with condominium termination. So this law is only going to apply to condominiums. It's not going to apply to planned communities. And it amends a section in the Condominium Act, sections 33-12-27 and 33-12-28. And basically, the gist of the law, it's talking about, terminating a condominium. So, ending a condominium, and it gives some certain percentages, which are important for associations to know if you're one of those associations who may want to terminate your condominium. One thing I'm going to mention is this is very rare that we ever see something like this. I think in 25 years or 27 years now of practicing law, I have only seen a termination of either a condominium or a planned community a handful of times over 25 years. So this isn't something that we see very often. But again, this new law applies only to condominiums. And it says that except in cases of amendments that may be executed pursuant to other sections of Title 33 of the CC&Rs, including the plat, may be amended only by a vote of the unit owners to which at least 67% of the votes in the association are allocated, or any larger majority the declaration specifies. It talks about a condominium may be terminated only by agreement of 80% of the unit owners, or any larger percentage if the declaration specifies. But there are two exceptions that you need to know about. In the case of taking of all the units by eminent domain, that is not going to be subject to this agreement of 80% of the unit owners. And also if the declaration specifies a smaller percentage, but only if all of the units in the condominium are restricted exclusively to non-residential uses. A condominium created on or after the effective date of this amendment to this section may be terminated only by agreement of 95% of the unit owners in the association, or any larger percentage that the declaration specifies. So the bottom line on this new law is that, once this, section, the change to this section in the law is going to go into effect in September. Once that happens, a condominium can only be terminated by agreement of 95% of the unit owners in the association. Prior to that, it's still 80%. But again, this is kind of a limited thing. We don't see termination of condominiums very often, as I stated previously. Okay, the last section is talking about short-term rentals and vacation rentals. This is a very hot bill for this year. And so we're going to talk a little bit about this. As you may know, back in 2016, our legislature amended, this requirements that cities used to be able to regulate short-term rentals through zoning and ordinances. And they would have certain areas zoned as transient housing. And if you weren't zoned as transient housing, which means nightly rentals, you weren't able to do nightly rentals. But in 2016, that law changed and took away the ability of cities, towns, and municipalities to regulate short-term rentals. And that was really a game changer for associations. And since that time, between 2016 and 2019, it was really very apparent that this was a bad move. And there's a lot of unrest in many resort cities like Sedona, where short-term rentals were just taking over the city. And, even the people that worked in Sedona weren't even able to find housing because so much of the housing had been converted to short-term rentals. If you go back to that time, the summer of 2019, at that time, Governor Ducey said he was going to, support legislation to fix the problem that was created by the 2016 legislation, which basically took away the city's ability to regulate short-term rentals. And then the pandemic hit, in 2020, and we kind of had two COVID legislatures in 2020 and 2021. And so this issue really wasn't adequately addressed by the legislature. Well, this year, this legislative session, they have made some pretty large strides in addressing this. So this bill is Senate Bill 1168. It applies to planned communities and to condominiums, and it sets forth the ways in which a city or town may regulate vacation or short-term rentals. And so these are some of the requirements that, landlords that have short-term tenants or short-term rentals will need to follow. So first, they are going to need to require the owner of a vacation or short-term rental to provide emergency contact information for the owner who is responsible for responding to complaints or emergencies. So first thing is there needs to be the owner must provide emergency contact information to the city. And this contact person, must be able to respond to any issues that come up on the short-term rental. The city or town can impose a penalty of up to $1,000 against the owner for every 30 days that they fail to provide the contact information. The second part of how this bill, in which the city or towns may regulate short-term rentals would be that now this bill allows for the city or towns to require the owner to obtain and maintain a local regulatory permit or license. And so each city is going to require that permit or license. In addition, the city or town is going to require, before offering a vacation or short-term rental for rent for the first time, the owner must notify all single-family residential properties adjacent to, directly, and diagonally across the street from the property. And so now it's putting the onus on the landlord owner to notify the neighbors that, hey, this is becoming a short-term rental. The city or town also is going to require the owner of the property to display a local regulatory permit number or license number, if any, on each advertisement for the vacation or short-term rental property that the owner maintains. And lastly, the city or town is going to require the vacation rental or short-term rental to maintain appropriate liability insurance to cover the vacation or short-term rental in the aggregate of at least $500,000, or to advertise and offer each rental through an online lodging marketplace that provides equal or greater coverage. And so it's kind of interesting to see how this law has, evolved since 2016. So it's obvious to me that the legislature, the mandate is that we're going to be trying to hold these short-term rental landlords and owners in HOAs and planned communities accountable. And the way to do that is to get emergency contact information, make them to take out a permit, notify the neighbors that this is becoming a short-term rental property. Again, it's just going to be only when the property is rented for the first time. Then they have to display the permit on each advertisement for the vacation or short-term rental property. And then they have to obtain liability insurance themselves, or if they're using a short-term rental company, they have to make sure that they are obtaining that insurance through them. This bill also goes on to state that a city or town may deny an issuance of a permit or a license for rental property for these reasons. Failure to provide required information that's needed for the permit, failure to pay the fee or the permit fee or the license fee. At the time of the application, if the owner has a suspended permit or license for the same vacation or short-term rental, it can be denied. Maybe the applicant provides false information, another reason for denial. Or if the owner is a registered sex offender or has been convicted of any serious felony in the last 5 years. Which is just kind of a random thing to include. It kind of surprised me, but anyways, it's just something that they added in there that the permit can be denied for that reason. A city or town that requires a local regulatory permit or license must adopt an ordinance to allow the city or town to initiate an administrative process to suspend a permit or license for a period of up to 12 months if there are 3 minor or 1 significant verified violation. And so really interesting how these laws are kind of expanding. Short-term rentals are here to stay. Okay, the only way that associations are going to be able to regulate short-term rentals is through CC&R amendments. There are these added protections that we're seeing the state putting into place now, where the cities are getting involved and requiring permits and notification to owners and, allowing an administrative process now But again, it's going to take a little while for these cities to get up to speed on this and start implementing these programs. So it'll be very interesting to see what happens with this new law as the effective date for all of these laws is going to be September 24th, 2022. So starting that date, all 5 of these laws will go into effect. And we'll continue to update you on any developments on these new laws. And I'm sure there'll be questions as things are being implemented in your associations. And we'll continue to talk about this throughout the rest of this year, 2022, and address issues that may come up, the questions that may come up as we navigate all of these new laws. We're going to be issuing a cheat sheet with a summary of all of these new laws, and that will be out in the very near future. So stay tuned, keep an eye out for that, but you'll be able to share that electronically with your boards and your homeowners if you so choose. Okay, let's switch to our next hot topic. Our first hot topic was pretty long, talking about new legislation, but it was a big legislative year, so it's important that we talked about those. We also had a very large judicial year in Arizona. So the second hot topic we're going to talk about is new judicial restrictions on amendments to CC&Rs. As some of you may know, there was a Supreme Court case in Arizona called Callaway versus Calabria. And that was issued by the Supreme Court of Arizona on March 22nd, 2022. And I think anybody in our industry, it applies, of course, to planned communities and to condominiums. And I think anybody in our industry will agree that this is kind of an unusual case for associations. And it's negative. It has a negative impact on associations. And so I want to just kind of give you some quick facts on it. The bottom line is the Arizona Supreme Court is making it more difficult for associations to pass and implement CC&R amendments. We think there are some pivots that associations can do to best manage this new case. But let's talk a little bit about the facts of the case quickly. Okay, so we're going to be sharing a copy of the case in our on the Zoom and on Facebook Live here with you today in case you want to read it yourself. So in 2015, Calabria Ranch, which is the association's litigation, was formed, and it was divided into 5 lots. And 2 of these lots were owned by Callaway, who is the plaintiff in this case. So there's only 5 lots in this association. This is a very small association, and 2 out of the 5 are owned by the plaintiff, Callaway. In January of 2018, the other owners of the remaining lots, so the other 3 owners, amended CC&Rs without Callaway's approval or knowledge. And Callaway was very upset about this and claimed that the amendments negatively affected him and his lot, which was almost 23 acres. And the other owners' lots, just for comparison purposes, were between 3.3 to 6.6 acres. So, he has very large lots. He, owns 2/5 of the land in the association. He wasn't even consulted on the amendment. And just kind of like as a baseline on this, I think the court really didn't like that. I think that the court was upset that the association passed an amendment to the CC&Rs without consulting and allowing all owners to vote on it. I think that's kind of the backbone of why they made this decision. And so basically what the court looked at the facts, and a couple of things that came out of this case were, the court was unhappy that the amendment was passed without Callaway even knowing about it or having a chance to vote yes or no on it. And the language that the 3/5 of the owners in the association approved as an amendment, the court didn't like the language. And basically, the first thing that the court said in this case is Arizona courts can blue pencil CC&Rs to eliminate language that is grammatically severable or has unreasonable provisions. And basically what this means is the court's now telling us that Arizona courts can strike language from amended CC&Rs where the court determines that the amendment is invalid. The Supreme Court also went on to state that the original declaration must give sufficient notice of the possibility of a future amendment. That is, amendments must be reasonable and foreseeable. And so in this case, Arizona courts and associations considering amendments to a declaration must look to the original declaration to determine, did the original declaration give sufficient notice to the members of a future amendment? In most cases, I would say yes. You look at the amendment provision in the CC&Rs, it's usually towards the end of the document. But the court even went on further to say that this notice provision in the original declaration must alert the owner to the fact that the CC&Rs can be amended to refine them, correct the error, fill in the gap, or change it in a particular way. Now, I guess to those of us who are industry insiders and have been practicing law in this area for a long time, I don't think I've ever seen a set of CC&Rs in 27 years that has that exact language that says these CC&Rs can be amended to refine them, correct an error, fill in a gap, or change it in a particular way. It's just not language that we typically see. So I guess the bottom line on this case is, it's perplexing. It's, some people in the industry are saying, don't do any amendments to CC&Rs right now, based on the Callaway case, because the court is really cracking down on amendments and they can blue pencil through anything that you do. That's not the approach that our firm is taking. Our advice is don't overreact, don't overcorrect. We still are doing CC&R amendments. We're still helping associations with CC&R amendments, but we are being very careful in how we are drafting the amendment provisions. We are including language in the amendments that mirrors the language that the Supreme Court of Arizona are suggesting, talking about, possibility of the amendment being refined, correcting an error, filling in a gap, changing it in a particular way. We are reacting to the ruling in a positive way. So we're taking what the court is telling us. We're doing our best to notify our clients of risks that there may be if they do amendments. And we're wording the amendments in such a way that the owners aren't going to be opposed to them. And we're filling in the amendments language that the Supreme Court is suggesting. And so, yes, we are being more cautious and careful as we're drafting the amendments, but there is a workaround on this. And so if your association is in a situation where you're deciding, hey, we haven't had our documents amended for like the past 10 years, you really should be updating your documents 10 years at least to get them consistent with the changes that have been taking place under Arizona law and, delete, old outdated language, et cetera. And if you're one of those associations, you may want to check out our cheat sheet. We have a great cheat sheet. For those of you who are familiar with our firm, we have over 60 cheat sheets on different topics pertaining to associations. And one of our most popular ones is amending association documents and implementing rental restrictions. And so that would be something that I would definitely suggest that you take a look at. And we're going to be sharing that with you on Zoom and Facebook Live. Okay, let's switch over and talk about another hot topic, which is rental properties. Our firm's cheat sheet, we have a cheat sheet on rental properties, which we have been fine-tuning over the years. We're going to be updating that as well based upon the new legislation that's going to be going into effect in September. But basically, I think we all can agree that there has been a large increase in Arizona in the number of short-term and long-term rentals in Arizona. So I think it's a really helpful thing to do to talk a little bit about what exactly is a short-term rental and what is considered a long-term rental. Because I understand from hearing feedback from my team, thank you, Mulcahy team, that some people are asking questions for what is a short-term rental. A short-term rental is going to be something that it could be less than 30 days. It could be 30 days or more. It could be 60 days. I mean, it really can be defined by your association's CC&Rs. Typically, we will see a short-term rental defined as less than 30 or less than 60 days. A longer-term rental is going to be typically like a year lease or a 2-year lease. It's important to remember a few things. If you are having issues with short-term rentals or just rentals in general in your association, remember that the CC&Rs are a contract between the association and the owner/landlord. And, the owner is responsible for making sure that they are complying with the association's documents, right? And any of their guests or tenants must also comply with the association's documents. If the guest or tenant doesn't comply with the association's documents, who's responsible? The owner. And we're going to talk a little bit in a minute about how do we handle bad, rentals or bad renters. And what's the best way to get the owner landlord to either evict the renter or to get the renter to behave and follow the association's rules. Okay, let's talk a little bit about the right of an owner to rent their property. So if we look at both the Planned Communities Act and the Condominium Act, owners have a right to rent their properties in a planned community or a condominium unless rentals are prohibited or otherwise regulated via the CC&Rs. And so basically the bottom line of Arizona law is that unless the CC&Rs have some sort of a restriction or a prohibition on rentals, whether they're short-term or long-term, owners are allowed to rent. If your documents are silent on renters, that means that owners are allowed to rent. Associations can have rental time restrictions in their CC&Rs. So maybe you're one of those associations that has a provision that says, owners can lease their property for a minimum of 30 days, or a minimum of 60 days, or a minimum of a year. That is totally legit under the law. It just needs to be in your CC&Rs. Okay, so if you have a renter in your association, what is the type of information that the association can ask for from the landlord regarding the renter? And this is just consistent with Arizona law. Arizona law dictates the specific things that we can ask the landlord for with regard to the tenant. So we can only ask for very few things. I'm sure this is going to upset some of you hearing this. Maybe you think that we can get more information, but the law is very strict on what we can require. So we can ask for the name and contact information for any adults occupying the unit or the lot. We can ask for the time period of the lease, including the beginning and ending dates of the tenancy. And we can ask for a description and the license plate numbers of the tenant's vehicles. If you're an age-restricted community, like a 55 and over community, we can ask also for a government-issued identification with a photograph of the tenant and confirmation that the tenant meets the association's minimum age requirements in your 55 and over community. So really, there's only 4 things we can ask for. We can, just the name and contact information of the adults occupying the unit or lot, how long the lease is, and a description and the license plate numbers of the tenant's vehicles, and then 55 and over verification if you are a 55 and over community. So what are some things that I typically see mistakes on by associations on this? Often associations want a copy of the lease. Often associations, want a copy of the credit report of the tenant. Neither of those things the association can require. And that's regardless, even if your association's documents say that the association can, get a copy of the lease or, more detailed information, that's not covered under this law, you can't do it. Some things that you want to think about is there are some fees that the association can charge, and these can be charged for short-term rentals. So even if you have like a nightly rental, or a monthly rental of a property in your association, or if it's, a yearly rental, a longer term lease, there are some fees that the association can charge. So it's important that you're aware of these. And again, if it's a nightly rental, you can charge this fee for each nightly rental. I mean, obviously, if it's, a tenant's coming in and doing like a Friday, Saturday, Sunday thing, it's one lease and you'll be able to charge these fees once for the same tenant. Okay, so in providing the information about the tenant, so when they give those 3 or 4 categories of information that they're required to give the association, we just talked about, the association can charge the owner a fee of no more than $25 for that information. And that can be charged for each new tenant, but it cannot be charged if the same tenants renew an existing lease. So if somebody has a 1-year lease and you charge the $25 to get the contact information for the adults occupying the property, how long the lease is, and the description of the license plates and the vehicle identification for the tenant's vehicles, you can only charge that $25 fee once for that 1 year. If they renew their lease, you can't charge that again. There is a $15 late fee if the owner doesn't provide this information regarding their tenant. And it has to be provided within 15 days after a postmarked request from the association. If they don't provide it then you can charge the $15 late fee. So remember that, oftentimes associations are hearing questions from our clients like, saying the owner doesn't provide us, they don't tell us when there's a short-term rental, they don't provide us with any information, and sometimes boards are jumping to, we want to levy a large fine. Under the statute, you can't do that. Basically, the statute limits us to charging the $25 for, processing this information, and then a $15 late fee if you request this information, regarding the tenant, 3 categories of information that we can have, and the owner doesn't comply, then we can charge a $15 late fee. Some things that we, also cannot ask for that I just want to bring up again would be the tenant's rental application. Like sometimes associations will say, hey, we want to see the rental application that the tenant filled out to rent the property. The association is not allowed to do that. We're also not allowed to get any other personal information regarding the tenant, like the tenant's job, or if the tenant, has any other private personal information that's not covered under the 3 categories of information that we can ask for. Some other kind of interesting areas or aspects of Arizona law on rental properties and HOAs and condos that I'd like to just kind of close out this topic on is the association cannot prohibit or otherwise restrict a member from serving on the board based upon the member not being an occupant of the property. So if you're an off-site owner and maybe you're leasing your property, the board can't say, that you can't be on the board or that you can't run for the board. So even if your documents say you have to live on the property, this law trumps it. So this kind of opens the door for owner landlords who aren't physically living on the property to still serve on the board. Another kind of weird part of this law is that an owner may use a crime-free addendum as part of a lease agreement. Now, this is the owner, right? The owner has the right to use a crime-free addendum. But this section does not prohibit the owner's use of a crime-free addendum. We have a great blog on this topic if you're more interested in that, and we're going to be sharing that with you on Zoom and Facebook Live. The bottom line on the crime-free addendum is, of course, you want to be renting, if you're an owner, to good tenants and making sure that there's no illegal activity going to be happening on the property, etc. Another interesting part of this law on rental properties is an association may lawfully enforce a provision in the community association documents that restricts the residency of persons who are required to be registered as a class 2 or 3 sex offender. And so what this means, and this was just kind of a weird throw in that they put in, back in about 5 or 6 years ago. And basically it's saying, it's kind of giving a green light to associations that if you want to implement a provision in your CC&Rs You want to pass a provision in your CCNRs to say that, hey, no level 2 or 3 sex offenders can live in our association. This provision appears to be giving the green light to do that. Now, as somebody who practices in this area for many years, I can tell you that I have only seen 1 or 2 associations in Arizona, and mind you, there's 10,000 associations in Arizona that have implemented, a no level 2 or 3 sex offenders allowed to occupy a unit or a lot in an association. It's a little bit problematic because I think there's some constitutional challenges here that could be raised and that could cause the association to incur a lot of legal fees fighting it. So if you're thinking about doing that, you definitely want to get some legal advice and understand the risks that somebody who is aggrieved by that type of a provision, might take this type of a case to the Supreme Court of the United States. The last thing that's really kind of an interesting part, I like this part of this law, is that an owner of a rental property is required to abate or stop criminal activity on their property. And if they don't, the owner can be held, criminally liable for the behavior of their tenant. And I've seen only one case over the past decade where this particular provision came into play. We had a bad landlord, actually like a slumlord, and there were all kinds of police activity on many of the properties that this landlord managed. And ultimately, there was a drive-by shooting in a particular association where the landlord was leasing to, a drug house, basically. And the landlord was held criminally liable. And, he was prosecuted by the county prosecutor's office for, basically running these slum houses. And so that is something to keep in our back pocket if we ever have a really bad tenant that has criminal activity that is going on in their property. We do have some legal remedies. We need to document it by going to the police. We need to, go to the prosecutor's office to see if it's the type of case that they'll be prosecuting. But it gives us some options if you have a really bad tenant that is violating the law. Let's see, I think we kind of covered everything on that particular topic. A couple more things just to close out. Remember that landlords must register their rental properties. Starting in September 24th, there's going to be some special registration permit type things. But they also have to register, previously they had to register, with the county. Previously, there's a Arizona revised statute 33-1902 that stated that an owner of a residential property located in Arizona is required to file a notification form with the county where the residential property is located. And the notification form had to indicate the property owner's name, the address of the property owner, the telephone number, street address of the residential property, and the year the property was built. Why was this being done? So that anytime that there is a short-term rental or a long-term rental, that the taxes are paid on that transaction. And owners who don't comply with this requirement after notification and a 10-day grace period are subject to a civil penalty of $1,000 plus $100 per month for every month the owner is not in compliance with this notification requirement. And so really, I think kind of the bottom line on these short-term, rentals is that they're clamping down on it, right? So you always had to register with the county, but now you're going to have to get a permit with the city or town that the rental property is located in. And you're going to have to give emergency contact information, and you're going to have to notify the neighbors. And these are all steps by our legislature to try to better balance the rental, whether it's a short-term or a long-term rental, balance the needs of the owner to rent their property versus protect the neighbors and the city or town, from any poor behavior by the tenants. So I think this is definitely a step in the right direction. I hope that there will be, I hope that this will be implemented quickly by the cities and towns. I hope that there will be consequences for landlord owners that don't get the permits. And remember, you can always snitch. So if your association has a bad landlord owner that is renting and not complying with this, you can contact the county and you can contact the city or town that the property is located in and ask them to investigate it. And I'm confident that based upon these new laws, they will. Okay, let's talk a little bit about some solutions for dealing with rental issues. If you have any problems with rental properties in your community, you may want to consider an amendment to your CC&Rs, maybe to implement longer time periods, minimum time rental periods. So maybe if you have no minimum rental periods right now, you may want to consider implementing by a CC&R amendment to have a minimum of 30, 60, or 90-day rentals. You may want to consider, you still have the right to fine the owner for violations of the CC&Rs by the tenant. So again, going back to, we can only charge that $25 fee for each tenancy or each new lease, as long as it's not a renewal. And then the $15 late fee if they don't give us the information within 15 days of making the request for the information. But we still can fine for bringing glass into the pool, or the tenant's dog not picking up after the tenant's dog, or loud parties. We still have the right to fine for that behavior, and we fine the owner for that behavior. And what I found over the years, many years of handling bad tenant issues, is the best way to get the landlord owner to comply is to require the landlord owner, hold them accountable and fine them for the behavior of the tenant, pursue our legal remedies, which may include going to Superior Court, getting an injunction, compelling the landlord to make their tenant comply with the association's documents. The best thing to do if you have a landlord that is leasing to a tenant is to have your attorney pick up the phone, call the landlord owner, and just tell them straight up, this is what's happening, provide evidence, tell the landlord owner, this is how much it's going to cost. We're going to fine you, we're going to go to court, and we're going to get an injunction against you. And, you're looking at $10,000, $15,000, $20,000 in legal fees, and maybe $5,000, $10,000 in fines for all this bad behavior. And in my experience, what happens with the landlord is this is a business to them, right? And once you explain to them how much this tenant is costing them, what do they want to do? They're going to evict the tenant, because this is a hot housing market right now. There's lots of people that are looking for good housing. And if they've got somebody that's costing them money and, cutting into their profits, they're going to want that person out. So I think that's an effective strategy if you have a bad tenant in your association. Having the attorney reach out to the landlord in a very firm phone call, explaining, here are the consequences, financial for you, and litigation, and this is how much it's going to cost you. And, I can tell you with 100% of the time when we've done that, the landlord evicts the tenant. Okay, so I think we've kind of covered as much as we need to on rentals. We spent a lot of time on it, but it is the number one issue in our office. Let's switch gears and talk a little bit about water rights, just something to keep an eye on for your association. So the Arizona Department of Water Resources has declared a goal of sustainable water supplies by the year 2030. And what this means for associations is that there are going to be some water reductions for associations in the coming years. And there's management plans that have been created by the Arizona Department of Water Resources. And basically, they're designed to hold the state accountable for water usage. And there's a total of 5 plans to be enacted over 5 decades. So it started in 1980 and it's going all the way to 2030. Currently, Arizona is now in the 3rd management plan. And this plan is going to affect HOAs, which maybe have more than 10 acres of turf. So that might be, some of the people here on this call today. And there are certain water allotments for those communities. And, as it stands for the third management phase, the allotment is compatible with plant, turf, and tree water needs right now. However, tighter water restrictions are ahead and they're coming up quickly. The fourth management plan is going to start in January of 2023. And this transition is definitely going to, promise smaller water reductions for communities with 10 or more acres of turf. It's something that associations that have this 10 or more acres of turf, it's going to start to affect you. So if your city, town, or municipality is offering any sort of free classes on water reduction, if you're one of these associations that has 10 or more acres of turf, you should be dialing into that. And we'll be sharing information on that if we see any of these types of classes come about as we go into that fourth management plan. But the biggest water restrictions are coming in the fifth management plan, and that is set to commence in 2025 or 2026. And this plan is going to reduce water allotments for turf to 4.77 acre per feet per acre. And so these are going to be smaller communities with smaller amounts of common area turf areas are going to start to be affected by this in 2025 and 2026. So we added this as a hot topic because this is something you need to keep an eye on for the future. If your association has a large amount of common areas and you are currently watering them, there is going to be some, specific things that you're going to have to do to adjust to some of the new requirements by the state of Arizona. And so we have, some information that we're going to be sharing with you. There's differences between the fourth and fifth management plan. We also have the fifth management plan for water allotments. And we hope that you'll keep this on your radar because starting January 2023, some of these associations that have a large amount of turf, 10 acres, these are going to come into play and affect your association. And then in 2025 or 26, most other associations are going to have these water allotments coming into play. So what are some things that associations can do in response to these new requirements for less water usage in your associations? Think about reducing water-hungry turf to reduce overall water consumption. Maybe start converting some areas into desert landscaping. And I know that the grant process for many different cities, towns, and municipalities just started up again because most of these cities, towns, and municipalities have a fiscal year that ended June 30th. And so how these grants work is you file an application for a grant, and your grant would be to convert turf to desert landscaping. In some cases, the cities, towns, and municipalities will pay 50% of the cost to do that, depending on what their formulas are and how much money they have. So that would be a great way to partner with the cities or towns or municipalities that you live in and get a grant from them to help you conserve water in your association so that you can be ready for when the fourth and fifth management plan on water reductions comes into play. Another thing to do would be start talking with your residents about water challenges coming up in the future and encouraging people to adopt and establish, their own, water consumption plans so that they're using less water, but also start the dialogue about the association may have to change how we've always done things. If you have a lot of turf, you may need to, change the turf to something else, or maybe you're not, every year doing a winter lawn. I mean, there's lots of different things that associations are doing. And begin thinking about ways to reduce water use as an association. That should be on your long range plan for your association, whether it's transitioning to desert landscaping or maybe using desert adapted, vegetation. All of these things are things that can help you minimize your water usage to comply with some of these new requirements. For more information on water rights for your association, you certainly can visit the Arizona Department of Water Resources at www.https new.azwater.gov. And my office is going to be sharing that link as well. Okay, let's switch gears and talk a little bit about inflation. Our last two topics here are kind of go hand in hand with the economy. As you probably saw recently, the inflation numbers just came out, I think, on July 12th, and we're at like over 9%, just barely over 9% inflation rate. What does this mean for associations? This means that you're paying higher salaries if you have any direct employees because there's a labor shortage. Gas prices are higher, cost of goods for your association is higher. It's difficult to find labor. It's difficult to get projects completed. Projects that maybe you bid 2 years ago, maybe it was 100,000. Guess what? Now it's 200,000 because the cost of materials has gone up and the cost of labor has gone up. Or maybe, you've got the problem where you've got a small project, you can't even get a contractor to come in and bid on it. Our old rule of thumb was, okay, whenever we have a project, we try to get 2 or 3 bids. Well, now we're hearing, and I even see this in my association, we can't get 3 bids. We can't even get 2 people to come out and build the property to give us a bid. And so these are all problems, sign of the times, right? The economy is out of control right now in terms of inflation, and there are problems. And so what are some things that associations should be doing if you're facing some of these issues where, hey, we budgeted this amount of money and we can't meet our expenses? So this is a good time to be thinking about your budget for 2023. And, you need to be budgeting adequately based upon these increases that we're seeing. And that is ultimately going to result in a higher assessment rate, or maybe you may have to levy a special assessment. And starting the communication and the dialogue with the owners about their need and why the assessment rate is going to have to go up is a very important thing to be doing. If you're in a situation right now or, at the halfway point, a little bit past the halfway point for 2022, and you don't have enough money to make it through the year, you may have to think about not doing some things this year that you planned on doing, cutting back. Of course, that's going to lead to deferred maintenance, which may cost more. You may need to do a special assessment and make sure you're following what your CCNRs say about how to do a special assessment. You may have to increase your regular assessment to meet the expenses, the additional expenses caused by inflation, and make sure you're following your CCNRs and getting advice from your attorney on what is the best way to increase our assessment in compliance with our association's documents. So just kind of a hot topic right now is inflation and the economy and how this is affecting associations if we can't get projects done. There may be times where we can't get the rebids. I think when you're presenting the bid at a meeting, you are going to have to say, listen, these are all the vendors we contacted to get a bid. We only heard back from 2. One decided to take a pass on it, so we have 1 bid. And we're going to have to stop making that 3 bid hard and fast rule for everything if it's just not possible. Now, obviously, any projects that are over, a certain dollar amount, whether it's 100,000 or 50,000, depending on how large your association is, you really need to have at least 2 bids for large projects. But we need to adjust our thinking a little bit. We also need to be very carefully looking at the financials and the budget, the year-to-date budget. Are we over budget? Are we under budget? What adjustments do we need to make? I'm really opposed to deferred maintenance because it just creates a pipeline of problems in the future. So, if you had to push off like our association, we need to resurface a tennis court. As a tennis player, I didn't really want to do that because the courts they really do need, some maintenance. But it's just something that we had to push off to next year because it wasn't a health and safety issue and we just don't have the money this year to do it. So sometimes you're going to have to make some difficult and tough decisions like that. Another hot topic, just to kind of round out today, is we're starting to see a spike in owners not paying assessments. And this probably goes hand in hand with the increasing costs of everything else that we're seeing, whether it's gas, groceries, clothing, all these prices are going up. And so a couple important things to just talk about as we start to see increases in the number of owners that aren't paying assessments. we haven't seen this, right? Throughout the entire pandemic, what we saw was owners paying at record rates. We had a number of discussions as a firm, when is the shoe going to drop? In 2020, 2021, are owners going to not be able to pay their assessments because of the pandemic? What we found was with the amount of money that the government was pumping into our economy and with the number of different things that owners were able to take advantage of, they had disposable money at their fingertips and they were paying their assessments. Now, kind of that money train has stopped and we're starting to see spikes in delinquencies. So what can your association do if you're starting to see owners not pay their assessments? Number one, look at the list of delinquents every single month. Maybe you had that on autopilot in 2020, 2021, no more. Every month you need to be looking at the owners who aren't paying their assessments. You need to be sending out courtesy reminder letters. You need to be leaning the property once it hits a threshold. Maybe it's 60 days past due, maybe it's 90 days past due. It just depends on what your policy is for your association. And you need to be getting it to your association's attorney to take the next step in a prompt manner. Maybe it doesn't go to the attorney until, $750 is owed or $1,000 is owed or whatever. But the faster we get the file, in terms of if I get it at $750 or $1,000, it's easier for me to collect the debt. If you give me the file when the owner owes $12,000, it's going to be harder to collect the money when it's that high. Then we get into the danger that the owner might be filing bankruptcy or something like that. So just some tips from the trenches. What's the best way to collect money from delinquent owners? A couple of thoughts. When a file is turned over to our firm, we do a 360 credit evaluation of the owner, and then we report back to you. Okay, so let's say the owner's name is Johnny Appleseed. We have a whole checklist of a number of different places that we look to determine Johnny Appleseed's credit. Is there a trustee sale on the property? Is the Johnny Appleseed paying his or her deed of trust or mortgage? Has he filed bankruptcy? Is this person employed? We verify employment. Are they still employed there? Look at their social media accounts. Are they on a trip to Hawaii? Well, apparently they've got money to go to Hawaii, but they're not paying their dues. We are checking LinkedIn to confirm employment. We are looking at, are they delinquent in the payment of their credit card bills? Are there any other judgments against them? Is anybody else searching their credit in addition to us? Maybe that means that there's not a judgment against them yet, but they owe other people money. These are all things that we look at and then we report back to you. We put it in easy to read format and we give you our recommendations on how to collect the debt. So really, that's the first thing we do when an association turns over a file to our firm to collect delinquent assessments from an owner. We do this credit evaluation, and then we determine, does this person have money? Are they employed? Are they upside down on their mortgage or deed of trust? What's the value of the property? And we, provide that information to you with a recommendation as to how to proceed. And typically we start out by sending a demand letter, a very firm demand letter threatening either foreclosure or getting a personal judgment against them in justice court. There are pros and cons to both legal remedies. So if we're going to foreclose on a property, we are only going to do that if either the owner is going to pay us because paid the association the amount that's due plus the attorney's fees that have been incurred. They're going to pay us if they don't want to lose their property. And if there's significant equity in the property, which right now there should be because the appreciation of the value of the properties has just gone hoopy the past 3 years, they're not going to let their property go away. So get taken away at a foreclosure. So basically, if the property is worth $250,000, and they maybe have a $100,000 mortgage or deed of trust on the property, that means there's $150,000 in equity. They're not going to walk away from that. So that's a good choice to file a foreclosure against them because they're going to pay. They're not going to let that property go away. And if they don't pay, somebody else will buy it at the sheriff's sale after we get the foreclosure judgment, and somebody else will pay us in full, meaning the association in full, the amount that is due. So that's a good risk to file a foreclosure against somebody that has, significant equity in their property. In some cases, we'll go to justice court, get a justice court judgment against the owner. If they are employed, we can garnish their wages or their bank account, it's sometimes a little bit harder to collect on that because we have to have the money in the bank account. There's a little kind of more uncertainty with that, with the foreclosure. At this time in this economy, that's probably the route that we're going right now. And it's funny because things changed. Back in 2008, we weren't doing a lot of foreclosures because there wasn't a lot of equity in properties. So you have to be working with a law firm that is really in tune with what's going on in our economy, what's going on with property values versus the amount of loans on the property, and thinking about how can I punch in the code to get this owner to pay, because that's our job, just to get the owner to pay and to make the association full. And then again, in terms of how much is owed, and make sure that the owner doesn't do it again and get behind from, every 6 months they're not paying. We want to make sure that we send a message that this is how this is going to be handled if you don't pay assessments. And there's a process, it's quick. And if you don't pay, you're going to be, in the hands of the attorney, and the attorney is going to be taking legal actions against you. So that's, our recommendations. Get on top of those delinquent owners. If you're seeing a spike in delinquencies in your association, get those liens filed, get it to the attorney for the association as quickly as possible. Because the faster that we get the file, the easier it is for us to collect the debt. Okay, let's see. I think we are coming to the very close to the end of our hot topics. I'm just kind of covering a lot of different areas here today. The kind of last thing I would talk about is political signs, because obviously we're in the season right now where we are seeing the primaries and national elections, and some of the state elections are going to be held in November. So it's a good time just to do a little primer refresher, okay? Remember that associations, have to allow political signs on an owner's property. Those signs can go up 71 days before the primary. It can be taken down later than 15 days after the date of the general election. So we're right in this time period right now, it's primary time period to all the way to the general election in November. So it's going to be 15 days after the general election. They will have to have those signs down. So just so you know that is, we have to allow it. Some things to think about are that, the flags. We're starting to see political signs as flags, right? And, our firm's opinion is that a flag can be treated like a political sign. If somebody wants to fly their flag, that's fine for political activity. It's my opinion that I would allow them to fly their flag, but the flag can't be offensive to somebody else, like a Confederate flag or something like that. The flag cannot contain obscenity or abusive language or anything like that. And so that would be the type of thing that the association would be able to require them to take that type of a political flag down. But these are all, these are going to be topics this summer. You're going to see political signs, political flags, and we're here to help you if you have any questions on anything unusual that may come up. Last but not least, I'm going to mention this electric vehicles and charging stations. This mainly is, I suppose it could come into play in planned communities too, but this mainly is going to be a condo issue. You're going to start seeing owners in your associations wanting the association to provide an electrical charging station. And as you may know, President Biden in August of 2021 signed an executive order that's going to push automakers to have 50% of all vehicles sold come equipped with a plug-in hybrid battery electric or fuel cell powertrain by 2030. So electric cars are, 50% of the production by 2030 is going to be electric cars. And so you kind of have to have a plan as an association. This should be on your long-range plan. If you're a condo, sometimes planned communities are providing electric charging stations as well, although mostly in a planned community, the owners have it on their property and they're providing it for themselves. In a condo, it's a little differently because the car is typically parked in a limited common element and there won't be any place to, put in their own charging station, although we have seen it in some condos where, the owner is supplying their own charging station at their own cost, and it's not something that the association is paying for. Something to think about, if you do decide to put in an electrical charging station, make sure that you're getting assurance from your local council. There may be a way to pass through the cost to your owners, like having a swipe, credit card swipe, where if they use it, they have to pay for the cost. You may have to convert a common area parking space to be used just for this, and there are some legal issues that may come up with that. We may see some laws with the Arizona legislature in the future. We haven't seen anything yet that talks about responsibilities of the association to do something like this, but just keep that on your radar. If you're a condo, you should be thinking about what is our solution on this. If an owner wants an electrical vehicle charging station, how can you work with them so that they put it, in the area where their vehicle is and that they pay the cost? Or if the association is going to provide it, how are we going to make it fair? How are we going to charge the owners that are using it, pass through the cost to them? And so we have some more information on that. If you're interested in or need help through that process, please reach out to our firm and we can provide you with some other things that we've done for other clients on this issue. Last but not least, sorry, this has been kind of a long class, but there's so many good hot topics that it's hard for me to narrow them down. The last one is online voting. We're seeing an increase in associations using online voting to vote for directors, elections, removal of board members, special assessments, increase in regular assessments, annual meetings. And so electronic voting is permissible under Arizona law. If your association is going through that process and you want to convert it to totally electronic voting, make sure that you're reaching out to our firm, make sure that you're using a company that is reputable, that because the third party is going to be handling typically the entire election, you want to make sure that they understand associations, that they've done elections like this in the past, and that they're aware of the special requirements under Arizona law, et cetera. But just a thought for the future, I think this is definitely something that associations are going to be doing more and more in the future, in getting away from, returning a paper ballot to now we're doing everybody's voting electronically on their computer. Thank you so much for joining us here today for class number 7 of our 2022 Virtual HOA Condo Academy series. This is our 7th class for 2022. We're going to be doing classes the third Thursday of every month for the rest of 2022. Great participation, and I would just like to thank all of you being here today and care about your communities to learn more so that you can follow the law and make good decisions for your communities. I'd also like to thank the different cities and towns and municipalities who are partnering with us to create these classes and provide these free educational opportunities for your residents. I call these cities Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Thank you so much for your partnership over the years. We have really enjoyed teaching these classes with you. To date, we have over 60,000 views, or almost 60,000 views of our videos of all these classes that we have put together since the pandemic started in March of 2020, which is amazing. Not only are we providing live education, but also all of this that we have taught over the past 2.5 years. All of these can be found on our website, so you can go back and if you see a topic that interests you, or you have a question on, you can revisit them by watching the videos. And those videos can be found on our website at mulcahylawfirm.com. So thanks again to the 183 attendees. This is like an all-time high, so happy. It's probably because it's so hot out, right? Over 110 today in Arizona. We just would like to thank you so much for being here today, and we hope you will join us for a few classes. And if don't forget that we have our first Friday coming up here, the first Friday of the month, which will be August.